Breaking news tonight on the Kyle Rittenhouse murder trial. The jury deliberating all day, but still no verdict. And now they have retired for the night. They were told, we are told, rather, they have asked the judge for written copies of their instructions, particularly the stuff about self-defense. What does that mean? Well, I don't know, but I know someone who does. This is a live look at Kenosha, Wisconsin. You can see protesters, those protesting in favor of and against Kyle Rittenhouse, and they have been gathering there. The fear, of course, that there will once again be violence when we do get a verdict. Hopefully that doesn't happen. Hopefully everyone has learned that burning things down and hurting each other gets you absolutely nowhere. If Kyle Rittenhouse is found guilty on any of the charges, he will potentially go away for a long time, could be life in prison for the intentional homicide charge. So what's going on behind the scenes right now? Joining me to discuss, former Assistant U.S. Attorney, National Review columnist, and Fox News contributor, the one and only Andy McCarthy. Welcome back, Andy.
Hey, Kennedy, how are you?
Oh, good, thank you. You know, obviously watching this with great interest, as many people are. There are a lot of opinions about this, but what does it mean to you that the jury asked for the specific instructions that they did from the judge? First, the part about self-defense, and then the rest of it.
I think, Kennedy, that the idea was they were going to send one copy of the instructions back to the deliberation room. And the instructions are like 40 pages long, so they wanted copies for everyone, or at least I think that's what they wanted. And it's what it ends up meaning, I think, for us as a practical matter is this is one of these unusual trials where there's not much dispute factually about what happened. So it really comes down to a legal question about whether there's a self-defense or not. And for trial watchers, for jury watchers, usually the way we know what they're focusing on, or at least we think we do, is because they send notes asking for, you know, testimony on this, point of law on that. But if this is mainly a legal thing and they've got the instructions, I'm not all that surprised that we went the whole day without getting another note, because I'm sure that's what the argument's about, self-defense.
All right, and how complicated is the self-defense aspect? What are some of the nuances, and how is it that this could go different ways?
Well, the self-defense is fairly simple in the sense that if you are an innocent actor and you are not the assailant, somebody is assaulting you and they're using lethal force in this case, or you have a legitimate fear of lethal force being used, you're allowed to use lethal force. So that's pretty straightforward. The issue in this case is, can the prosecution convince the jury that Rittenhouse somehow forfeited his right to defend himself by either acting in a way that was criminal or provocative that made other people or inspired other people to attack him first, under circumstances where he'd be deemed as a matter of law not to be able to use lethal force to defend himself. That's what they were trying to sell the jury on. I don't think they did it, but that's their theory.
Yeah, and you kept hearing that term, provocative. He was provoking the crowd. There were heroes at the protest, all of those things. So let me ask you this, because, you know, you were a prosecutor for a long, long time. You don't typically see assistant district attorneys pointing a gun at a jury. Is that usually a good idea?
Yeah, that's never a good idea, not for a federal prosecutor, a state prosecutor, or anybody else. You know, when I was a prosecutor, and this is like ancient history at this point, right? But they drummed into you that we were supposed to be very overt with the jury, that the guns were disarmed and they couldn't be fired, because it's disturbing to be a few feet away from jurors and have, you know, these firearms.
Especially with your finger on the trigger. I mean, this guy obviously is completely irresponsible, or he has no idea what he's doing. You know, that's how a woman died on Alec Baldwin's film set. I couldn't believe what a dum-dum that guy was.
Yeah, it's also, Kennedy, it's also strategically dumb in the sense that the prosecutor wants the jury to think that the gun's a really dangerous weapon. Because the jury's looking in the courtroom at the defense table where the defendant is sitting in a nice suit, you know, with a benign look on his face. And you want to be reminding the jury that the defendant was out on the street with the gun, right? So you don't want to treat it like it's a game, and you don't want to treat it like it's some, you know, some kind of a cops and robbers
That's a great point.
kind of thing. You want to treat that
and was waving
like
it
it's
around.
a really dangerous weapon.
Yeah, he's waving around like it's a toy. And I think he actually undermines his own stunts. Andy McCarthy, thank you so much. If we hear more, we will lean on you in the coming days. Thanks again.
You got it. Thanks.